Facebook because it might be deleted. I don't know. I have a funky habit of deleting stuff. Um, let's go ahead and just get into it. For those that don't know, or for those that do not understand, there is supposed to be a shed out of $42 million. And I'm gonna go into my Gmail. I'm gonna read off why the CFPB said what they said, and I'm gonna just tell y'all what's going on in particular. Like the live and share the live. I'm gonna be doing a bunch of stuff at one time. But I'm gonna make sure that I get out as much information as possible because it is important. Me personally, I'm gonna be completely honest and transparent. I wholeheartedly do not like to repeat myself, but unfortunately, because people do not understand or people do not have access to the information, which again, I'm not really understanding, but to each his own. We hope you and your loved ones stay safe during this warm winter storm, Cora. The majority of our customers who experience interruptions restored, da da da. Okay. Anyway, so let me go into. Give me a second, y'all. The CFPB. Okay. Let's have a conversation about that. We're gonna have a conversation about that right now. So y'all like the live and share the live. I'm gonna read it out to y'all. I wish I could show it to y'all more than anything, but I don't have the capability to do it right now because I don't have my tripod. I don't have a bunch of tripods to kind of hold it. You can look it up if you would like. That's to your discretion. But I'm gonna go ahead and read it to you and why it's $42 million. Okay. And then I'm gonna also read off specifically what violations would qualify for a piece of the settlement. So let's go here. Let's start here. The Consumer Financial Protection Bureau versus USASF Servicing LLC. Okay. If you want to look up the case, you can type in Consumer Financial Protection Bureau, which is the plaintiff, versus USASF Servicing LLC, which is one of US Auto Sales entities. Okay. It says the court having granted the plaintiff, which is CFPB, a motion for default judgment, it says is hereby ordered, adjudged, and decreed that the judgment is entered in favor of the plaintiff, which is the CFPB, and the following amounts. It says compensatory damages is 25,519,366. Restitution in 5,833,966 plus prejudgment interest on the amount of 1,274,357 with a grand total of 7,108,323 and 10 million in civil penalties. That is what the judge went ahead and agreed. So if we add up all the total, this is why the amount came out to $42 million. So you got the civil penalties, which is 10 million, 10, 1, 2, 3, 1, 2, 3. Then you got the 5 million plus the 1 million, which gave them a total of 7 million. So you got the 7,108,323 plus then you got the 25,519,366, and that gave you 42,627,689. We don't know if that includes taxes or not, but that's the full amount of what the company is ordered to pay out to US Auto Sales customers, right? The reason why they have to pay that out, I'm going to read what the judge put into place. It says, the court on August the 28th of 2024 entered in an option and an order on the plaintiff, which is the Consumer Financial Protection Bureau, motion for default judgment, finding that the civil action was not stayed by the filing of the defendant's bankruptcy, finding that the defendant is liable for the violations the Consumer Financial Protection Act, which is 12 USC 5481, and determined that the injunction relief was appropriate in that option and order. It says, however, the court directed the Bureau to supplement its evidence regarding the damages, and the Bureau has done so. Accordingly, the court returns to the Bureau's motion where it left off on the issues of the damages. And it says this is what was discussed. It says the Bureau seeks restitution of unearned gap premiums. So that means if you paid a gap premium and it occurred interest in any type of way, but you didn't get it back after you completely paid off your vehicle. For example, it doesn't matter if the account is with U.S. Auto Sales or Westlake Portfolio Management or any car company. What you need to know is if you fully pay off a car in its entirety, the gap coverage must be refunded back to you if you have not canceled it plus interest. Compensatory damages and wrongful activation of starter interruption devices and repossessions and civil monetary penalties. To calculate the restitution, the damages, the Bureau relied on a flat amount asserted to the representative in the injury suffered by the consumer. The court directed the Bureau to supplement its evidence with an expert testimony providing on some of the basis within reasonable degree of the confidence that these flat amounts are representatives of the classes of the injuries of the consumers generated faced in this case. To support the motion, the Bureau relied on a declaration of the auto finance senior programmer manager, Mr. Christopher. It says, from the declaration, the court can conclude that Mr. Christopher is qualified as an expert by knowledge, skills, expert training, or education, including law school education of at least 15 years, working as an analyst and policy specialist, focusing on the auto financing market. Now, I want you to listen to what Mr. Christopher suggested as options for payment for consumers. This is what he said. That's why I said you never know what your check will be, but here are the options that he said. Mr. Christopher offers 3 primary options, just 3. That $5,000 per repossession is a reasonable estimated amount for the economic harm and distress suffered by the typical USASF consumer who faced wrongful repossession. So if you got your car repoed and you called them and said, hey, my payment is going to be late, and they still came and repoed your car, that is considered wrongful repossession. And as a form of damages and payment, he said an option of $5,000, right? The second option was that $500 is a considerable amount for harmful suffering of the typical customer who had their car disabled. So, for example, if you had your car disabled 6 times, that's 500 times 6. I don't know how many times you guys gotten your cars disabled. I don't know. That was the second option. Now, mind you, it's only 3 options that he suggested as an expert. These were the 3 options, all right? Then he goes to say, then there's another option for $100 a day as an estimate for the harm of suffering by a typical customer who had warning tones. $100 per day. Now, in the previous actual complaint that the Consumer Financial Protection Bureau did against USASF, they stated that the warning tones are only supposed to be on there for 4 days. So that's already $400 right there. Anything over those 4 days, you're getting $100 per day. That's what he was saying as estimated for the warning tones. Mr. Christopher based these options on his years of studying the auto lending industry, his knowledge of the industry operations, his review of the relevant academic literature, and his review of the declaration from consumers affected by the defendant's action, among other data. Then he goes to say that the court finds that Mr. Christopher's testimony meets the requirements of the expert rule under Rule 702 and will therefore accept the evidence as a part of the court damages and calculations. It says, in addition, the court has reviewed the material and submitted in support of the Bureau's motion, find the following defendant wrongful disabling the vehicle, causing at least over $3 million in damages for consumers. They wrongfully activated the starter interruption alerts. That was over $2 million in damages. Wrongful repossession was only $508,000 for consumers because it wasn't that many people that got their cars wrongfully repossessed. Then it goes and says defendants did not get the refunds. Thus, consumers were due $5 million for gap premiums and charge-offs. That's an additional $3 million. And for those that did not pay, for those that did not get the full refund or half the refund, that was an additional $1 million for whose loans were paid off early. Then they go and say restitution was an additional $5 million. And they said the method of this calculation was based upon 17 CFR 201600. It's an appropriate method for an additional $1 million. And this is what they were calculating up, and that's how it equaled up to the $42 million. So they sent this over. Let me explain something. The company US Auto Sales have a total of 6 different entities that work along with US Auto Sales. US Auto Sales is where you bought the car. US Auto Finance financed the car. USASF is who you were making your payments to every month, bi-weekly, weekly. That's why the Consumer Financial Protection Bureau sued them, because that's who took your money for all these violations. Okay? Every violation that happened for the customers who purchased their vehicle between 2016 and 2021, you will be compensated. I just let people know that, number one, the Consumer Financial Protection Bureau will have the information because US Auto Sales have, number one, admitted that they did all this wrong stuff. They admitted to everything that they were accused of. They were accused of wrongful repossessions. They were accused of wrongfully shutting off your cars. They were accused of double billing. They were accused of not giving you the full gap refunds and not giving half of it out. And they were accused of all these things. And they admitted to all of it and thought that they were going to get away. Let me explain something. Somebody's going to pay. Don't worry about whose pocketbook it's going to come out of. We don't know if it's going to come out of Westlake Portfolio Management pocketbook, or is it going to come out of US Auto Sales pocketbook? Because what people don't understand or what people don't know, there are a lot of things that happen behind closed doors for a particular reason. So behind closed doors, for those that don't know, when you do register a company with the Security and Exchange Commission, you have to put what you owe, what you make, how much you feel like you're worth. You have to put all that information out there. For those that don't know, US Auto Sales put out there on the Security and Exchange Commission that they were worth $700 million. Now, whose pocketbook that's coming out of, I don't know. It may be US Auto Sales. It may be Westlake Portfolio Management that's going to pay the $42 million for those customers. We do not know. Please don't ask that question anymore. I think that is the craziest thing that I ever heard, especially if I say it over and over again, that number one, you have to have bought your car between 2016 and 2021. Number two, you have to have suffered any of the violations that they have already admitted to. If you did not suffer any of the violations that they admitted to, and you did not buy your car between those years, then don't ask, do you qualify for this? No, you do not. Okay? I keep getting random DMs, and I don't like answering DMs no more because everybody keep asking the same question. All right. Number two, how they going to get my information? Number one, US Auto Sales had to provide all the information for all the people that they fucked over. They got to provide a list. Hopefully you have not moved. Hopefully you have not changed your number. Hopefully you have not changed your email. Not to say that they're going to send you a check via email. If you know that you have moved, make an account with the Consumer Financial Protection Bureau and keep an email address and keep the correct address. Because for those that don't know, the Consumer Financial Protection Bureau is going against every company that they can and making sure the consumers get their just due. And they're sending out random checks. Okay. With that being said, don't question who's going to pay it. Just question the fact that, don't even question it. Just know you're going to get a check in the mail. How about that? Stop worrying about whose pocketbook is going to come out of. Just know you're going to get a check. All right. Boom. Only if you qualify for that. If you don't qualify for that, let me explain something. There is another lawsuit that is happening. It is the Consumer Financial Protection Bureau versus Westlake Portfolio Management on behalf of U.S. Auto Sales customers. At this time point in moment, it went from a class action lawsuit. Nobody has to sign up for it, because that's the first question that people gonna say. How do I sign up for it? You're automatically signed up. The only way that you don't get any of the pie is if you tell them, I don't want none of that. I don't want none of that. Please stop asking, is it for Georgia? Is it for Florida? If you are a U.S. Auto Sales customer, then clearly you qualify. I want you guys to stop and think about the question before you ask it, because yeah, some of that stuff I feel like y'all shouldn't be asking. Asking, is it for Georgia? Is it for Florida? Is it for South Carolina, North Carolina? Stop asking that question, please. Swear to God, don't ask that question no more. Because if you're a U.S. Auto Sales customer and you suffered a wrongdoing that they already admitted to, and you purchased your car between those years that I told you, why are you asking, is it for me? Please stop doing that. Y'all are killing me with that. The class action lawsuit is now currently in arbitration because Westlake Portfolio Management actually provided something called a try agreement between the parent companies of U.S. Auto Sales and them, saying what they can do. Now, me personally, me thinking like a logical person, I don't feel like that's a valid contract. But hey, I'm not a judge. I'm not a lawyer. I don't give out legal advice. This is just kind of what it is at this point. What else? So that's what's going on for the other people, as well as I also tell people the other option that you might want to consider is calling the Delaware bankruptcy. Now, for those that don't know, or for those that don't get what's going on, you do have an opportunity, if you feel like you are owed money from U.S. Auto Sales, to file a claim against them in Delaware bankruptcy, but yet you must provide proof. Do not say, I told you to file a claim against Delaware bankruptcy without having proof, because it specifically says it in the instructions that if you do not have proof and that you are filing a fraudulent claim without proof, number one, you may get denied. Number two, if you're not denied, you will get a hefty fine. A $10,000 fine. You may get a $10,000 fine. Or you can suffer 5 years in prison. Don't say, well, Navadia taught us to do this. No. I've said this multiple times, many times. I am not a lawyer. I do not give out legal advice. I do not give out financial advice. I'm here for educational purposes and experienced information. So from experience, I do know that the judge is basically requesting that the CFPB get paid out first. The judge here in Georgia is requesting that whoever need to pay out the CFPB first. After that, whoever is left that is owed, then they will get the checks. That is just my thought process. Again, I do not know how bankruptcy works because I've never done bankruptcy. I've never claimed bankruptcy. I've never been in the midst of bankruptcy. But I do know this. If you call the people that are getting paid to do this job, which would be to tell you what steps you need to take, it's going to be so much easier for you. Don't overcomplicate this situation. Call the Delaware bankruptcy. I'm not going to give out the number. All y'all have to do is go to Google and look up Delaware bankruptcy court number. The number is going to pop up. It's going to pop up. Okay. Now, if you want to make sure that you do the correct thing and have your proof, you need your contract. Mainly the first 2 pages of your contract is really going to be what's best. The first 2 pages, that would be this one and this one. These two right here. A lot of people are saying that they don't have their contracts. Here's why I say everything go hand in hand. Well, if you make a complaint to the Consumer Financial Protection Bureau about not having your contract, then Westlake Portfolio Management has to be forced to find the contract that was sent over and give it to you. And then you will have proof. And that's why I say everything works hand in hand. Okay? For American Car Center people, for those that don't know, there was a case that just went to federal court in Florida against American Car Center. They are not in bankruptcy anymore at this current moment. So somebody is in the middle of arbitration right now against American Car Center Company. Well, really Westlake, but and that's public knowledge. If you got access to Pacer, you can look that up. I promise you. Funniest shit ever. Now, I will say this. That person had an attorney, and that attorney went against American Car Center. That's Westlake. And they also went against two of the credit reporting agencies. I can't remember. Matter of fact, let me look it up and stop assuming. Let me stop assuming and go back. Let me go back. Hold on. And I can tell y'all who they went against. All right. So this person who had an American Car Center car went against Equifax and Experian and Westlake Portfolio Management. Equifax and Experian settled. They settled, as they should. Westlake Portfolio Management, there and that person who had American Car Center, they're currently in arbitration right now at this current moment. And this actually started on May the 22nd of 2024. And right now, December the 16th of 2024, that's when they took off Equifax and Experian because they actually settled out. So now they've submitted arbitration with AAA against Westlake Portfolio Management. So don't say that it can't be done, because it can be done. It's public knowledge. It's out there. It's not something that's hidden anymore, that you can't just stand up against these folks. You definitely can. Far as who else? What's the other company? Credit Acceptance. Credit Acceptance is going against a lot of people because they're trying to get as much money as possible. Stop letting these people run over y'all. Stop letting these people run over y'all. I am actually preparing. I was gonna do the credit reporting agencies, but I'm gonna just let them be. But I am gonna do two companies, and I am going to stop at federal court tomorrow. That's why I had to take out my weapons, because I'll be so ignorant, I will forget that the weapons are in my in my bag. So yeah, that's the plan. The plan is to drop off my paperwork to federal court. And of course, I would love to take you guys with me, but federal court do not play that. Okay, there are no cell phones, no laptop. There is nothing. You can't bring nothing in federal court. So I can only take y'all to the front of the building when I walk in, and the front of the building when I'm walking out. That's all I can give y'all. But I have to finish putting my stuff together, and then I'm gonna make it work. I'm gonna twerk on you, feel me? And handle my business. I'm gonna leave the credit reporting agencies alone for the time being. But that other company and that other company, yeah, we're gonna make something shake with them. I ain't even finna trip off them no more, for sure. I'm gonna make something shake with that tow company and that other company, and still debating if I'm going back and forth in my mind about this whole breach of contract, because in a technical sense, well, no, we can say that they still did a breach of contract because they didn't uphold their end of the bargain. So it's cool. I will make copies, because according to the rules of federal procedures, I can possibly do a prosperous affidavit. I have to go back. Hold on. Because what people don't know, this is the part that people don't be telling y'all. Like, people will be like, yeah, you got to go to federal court. You got to go to federal court. But they're not going to, like, run down the procedures of this shit. And it's so weird when people say it out loud. And I be looking at them like, why y'all keep telling folks to go to federal court knowing that it's $405? You haven't even explained to them that they have an option or opportunity to either push uh the cost of court to the side or do a prosperous affidavit. And that's just me reading it, because where am I at? Rule 4 of federal civil procedures, it talks about how you have to have this paperwork, a copy of the summons, served. But you, the plaintiff, cannot serve it. You have to get somebody else to serve it. And they talk about how you can send a copy over to, you know what I'm saying, certain people or whatever the case may be, but they, by delivering the summons and the complaint to an officer, a managing or general agent, or any other agent authorized by, appointed, or by law. So what people don't know is my court case originally, the one where I canceled the contract, the company that was pretending to represent or be U.S. Auto Sales said that I never gave to the correct people. But at that time, whoever is the general agent or whoever is authorized to get those summonses, which most of the time is their registered agent, took it. Now they do say this, which I think is interesting, and I guess I'm gonna have to figure that out tomorrow. It says that, is this still Rule 4? Yeah. In Rule 4, hold on, I'm trying to make sure that I got this correct. If I return the signed waiver, because they talk about the signed waiver, if I file it in court, the action will then proceed to be served on that day. Waiver is filed, but no summons will be served on you, or you will have 60 days from the date the notice has been sent out to answer the complaint, and 90 days to respond. Oh, that ain't what I was looking for. I was looking for something else. Hold on. All right, I'm finna get off of Facebook because that phone is about to go dead, but I will stay on TikTok live. If you don't know what my TikTok is, it's Dirty Joe, DURTTY_JOE. I will not be keeping this live up on Facebook, unfortunately. So my bad, y'all. But I'm about to get off here because I gotta charge this phone up. Bye, y'all. I think it's this one right here where they talk about serving people. I think this is what it is. Serving people. I'm trying to think. They got a rule in here where they talk about how they might appoint like a marshal or somebody to go ahead and serve it for you if you do a prosperous affidavit. That's just from what I am reading. So it says, where is it at, bro? Because I know I read it. It is Rule 4. Hold on. Let me go back to the top because I got to make sure that I'm not tripping. All right. So Rule 4 talks about the summonings and the format that it's supposed to be in. Then it says on 4B, it talks about insurance, which is really weird to hear. But it says this: on or after the filing of the complaint, the plaintiff may present a summons to the clerk for signature and seal. If the summons is properly completed, the clerk must sign, seal, and issue it to the plaintiff for service on the defendant. Then it goes to say a summons or a copy of the summons that is addressed to multiple defendants must be issued for the defendant to be served. So basically, whatever I type up today, I got to make a copy because it's going to be 2 defendants and I'm the one plaintiff. And then it talks about C, 4C, which is talking about service, it says in general, a summons must be served with a copy of the complaint. So I gotta have a copy of the complaint. Then it says the plaintiff is responsible for having the summons and the complaint served within the timely matter of Rule 4M, and must furnish the necessary copies to the person who makes service, by whom any person who is at least 18 years or older, not a party, may serve the summons to the complaint. May serve the summons. So basically, if I wanted to pay somebody off the street to serve the company, I can, as long as they over 18. I can get it served by a marshal or someone specially appointed at the plaintiff's request. Listen to this. At the plaintiff's request, the court may order the service be made by a United States Marshal or Deputy Marshal, or by a person specially appointed by the court. The court must so order if the plaintiff is authorized to proceed in a former prosperous under 28 USC 1915, or as a seaman under 28 USC 1916. So let me see what this is. Hold on. Copy the text. I like to look stuff up. I don't know about everybody else. That's why I be telling folks. Proceeding in a former prosperous, notwithstanding a prisoner or let's see. Hold on, let me click on it real quick. So proceedings in a former prosperous, authorize any suit, action, civil, But see, that's the only thing about this. A judgment may be rendered for the cost of the constant. But I am not, unfortunately, I am not a prisoner. Unfortunately. So I'm not that. But they said, indeed, waivering the service, requesting a waiver, an individual, a corporation, or an association that is subject to serve under Rule 4E, which that's the next one, A, B, C, D, E, yeah. 4E, F, or H has a duty to avoid unnecessary expenses or services and summons. The plaintiff, which would be me, the plaintiff may notify such defendants that an action has been commenced and request that the defendant waive service of the summons. The notice and the request must be written and addressed to the individual defendants or for the defendant subject to service under Rule 4H. To an officer and managing name the court where the complaint is filed, be accompanied by a copy of the complaint, 2 copies of the waiver form to Rule 4, and a prepaid meaning for the return form. Inform the defendant using the form state request. Give the defendant a reasonable time of at least 30 days to return it. Be sent by first class mail or reliable means. Failure to waive. If a defendant located within the United States failed without good cause to sign and return the waiver requested by the plaintiff located within the United States, the court must impose on the defendant the expenses later and occur in making services, and reasonable expenses include attorney fees of any motion required to collect. So basically, I could put the cost of court to the side, but I could also send them over the payment and force them to pay it. And if they don't want to pay it, then when everything is done, they'll still have the obligation to pay that. But they got 60 days to respond for that. Jury and venue not waived. Service, let me see. All right, so I kind of already know. Yeah, I kind of already know what I'm gonna do. I'm not upset. I just need to get it done. This situation has been like wrecking my brain. Um, this situation has messed with me wholeheartedly. Dealing with a company that know that they did wrong, and I'm supposed to be silent, and I'm supposed to not say nothing. It's just really weird to know that Westlake Portfolio Management really tried to do me dirty and still like on some, you know, that type of situation. It kind of it fucks with me. The tow companies, I feel like they're even worse because they sit up here and they do the dirty work. They know it's dirty, and I get it. You got to do a job. You got stuff that you got to handle, but at the same time, if it's dealing with litigation, there's no way possible that y'all think that this shit is okay because it ain't. Like it's not okay for y'all to take somebody's car in the middle of court proceedings, and then when you request to get that back, you don't give it back. And then you say, "Oh well, we have to get authority from Westlake Portfolio Management to even give you the car back." Wait a minute, there is no contract, so you can't get authority from them at all because they don't hold the obligation. I canceled the contract in its entirety, so whoever you're saying that gave y'all authority to do something, they no longer have authority because there is no contract. I don't know. Like I said, it's a lot of weird shit, but I got some things that I must accomplish. So I'm super duper excited. And yeah, I'm gonna make it happen, and I'm gonna keep moving. I'm gonna print out my forms. I will be at the courthouse tomorrow in the morning. I mean tomorrow in the afternoon after I finish training at my job. And yeah, that's how we're gonna make it work. And all that good shit. Bye y'all.